from the date of you joining the government service.
So that is for 224. So
220.
for a deduction from my salary is invalid. Then they cannot be done. They just pass on one week's
all these matters which was referred to by is in those matters there was an order wherein they said that you are not entitled to, or any regulations which were challenged. The division bench of this court is that in that there was yes. Yes, it is here. Yes. Ahead. Yes. Yes.
and other benefits. Cases. So we are depending on cases.
Yes.
Also, 36. Next 36. 4. Respect of employee, the university here rendered. Benefits shall be administered subject to guidelines right. So therefore, insurance benefits are available to us in the cases.
Yes. Yes. Yes.
Now, so far as the representation. One and going to both.
Yes.
ಅಡಿಯಲ್ಲಿಯೇ ಪರಿಗಣಿಸಲಾಗುತ್ತದೆ. ನಿಯಮ 36 ಹೆಚ್ಚಿನ ಸೇವೆಯನ್ನು ಪರಿಗಣಿಸುವುದಾಗಿ ಸಂಬಂಧ ನಿಯುಕ್ತಿ ವೇತನ ವರದಿಯನ್ನು ಸರ್ಕಾರವು government has referred that is communication. Is equally required. ವೈದ್ಯಕೀಯ ಪಶು ಹಾಗೂ ಬಿತ್ತರಿಕೆ ವಿಜ್ಞಾನಗಳು ಅದೇ ರೀತಿ ಯೋಜನೆ
Yes, funny.
ಒಂದು 4-2006 ಎಲ್ಲಾ ನೇಮಕಾತಿಗಳಿಂದ ಪರಿಗಣಿಸಿ ಪಿಂಚಣಿ ಯೋಜನೆ ಅಡಿಯಲ್ಲಿ ಒಳಪಡಿಸುತ್ತದೆ. ಇಂದಿನ ಪಿಂಚಣಿ ಯೋಜನೆಯಲ್ಲಿ ಸೇವೆಯನ್ನು ಪರಿಗಣಿಸಿ ಪಿಂಚಣಿ ಯೋಜನೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ನೇಮಕಾತಿ ಹೊಂದುವ ನೌಕರರ ಕಡ್ಡಾಯವಾಗಿ ವ್ಯಾಖ್ಯಾನಿಸಿದ ಅಂಶದಾಯಿ ಕೊಡುಗೆ ಯಾವುದೇ ವಂತಿಗೆ ಆಧಾರಿತ ಭವಿಷ್ಯ ನಿಧಿ ಎಲ್ಲಾ ನೇಮಕಾತಿ ಹೊಸ ನೇಮಕಾತಿಗಳನ್ನೇ ಪರಿಗಣಿಸಲ್ಲ. ಇದರಿಂದ ಇಂದಿನ ಯಾವುದೇ ಸೇವೆ ವಿಶ್ವವಿದ್ಯಾಲಯ rejected.
This is a general ನಿಮ್ಗಂತ ಕಳಿಸಿಲ್ಲ. That is not been. But then what happens to that provision of 224B wherein it states when you have been entitled for qualifying service?
We are not on that. We are on the pensions. Once we are admitted,
then comes the question of then at the time of qualifying the pension, then comes the representation to be.
They have started depending on our continue recovery. Treatment recovery.
For dictation tomorrow.
Yes.
Who has replied yesterday? You replied, right? ಮಾಡಿದ್ದೀರಲ್ಲ. You place that on record. Then what is that you want to say? What is that? What is that? So they have adapted that modalities. So this has to be adapted by Karnataka also.
Matter has been examined in consultation scientifically, but has been decided as to require the dedication from so how to pass an option for intermediate or state government or central or state autonomous body to office for the purpose of eligibility benefits. On their final retirement from the central government, central autonomous body subject to fulfillment of all other conditions. That past service is the in terms of BPR of the system of various points.
What do you want to substantiate by reading?
Next that's an option may be exercised within 3 months of issue of this office. That employees who are appointed under LPS during 1 month 2004 to 10 2009 and are eligible to exercise option in terms of parafiling. That is cut off date in 2009. Service for the purpose of pensionary.
So there is a limitation prescribed according to you. So within 3 years they had to file this.
3 months of this office.
3 months. That is. So according to you, the deduction is in the absence of they are giving such a representation to. What would happen if this petition is being treated as a representation? Yes. Could have given it to them. Correct. We can take this writ petition as a representation, consider the representation, and then pass this order as per the judgment by this. Yes. So this should be taken as a representation and submitted. So now that you have this notification came to your light only today. So you correct. But anyway, if he's making that is what exactly this court wanted to tell you before he would have made this submission.
Yes.
Such as representation can be given to the authority. The authority should take this as a representation, and in light of the judgment delivered by this court, by the division bench of this court, in that this pretext it should dispose of the let them till the disposal of that consideration of that. Yes, and that is. Yeah, it should. Let the counsel you appear for the respondent number 3. Respondent number 3, university has placed on record, cited by way of a memo. Based on record, the notification issued by the Department of Personal Affairs, Government of India, Ministry of Personnel, Public Grievances and Pension Department of Pension and Pensioners Welfare by way of an office memorandum dated 11th June 2020. Content that from the date of notification issued by the central government, an option was to be exercised by the petitioner within 3 months from the date of issuance of the office memorandum. The said memo is taken on record. It's filed by our we will dispose of it yes, it's an option. Yes. Since the grievance of the petition in common, all the petitions are taken up to judge. Seeking a writ of mandate, directing the respondents to consider the petitioners under the old pension scheme along with the benefits ensuing from it. Further, the petitioners have also sought for a direction against the respondent to discontinue collection of employee contribution under the new pension scheme and to refund the monies collected as so far under the draft of new pension scheme. The facts of the case are that the petitioners were appointed as a veterinary doctor by the Karnataka Public Service Commission (KPSC) for short, under the Karnataka State Civil Services direct recruitment by selection (complete rules 1973) and discharging the duties as a veterinary doctors in various places of Karnataka. The Karnataka next parish. The Karnataka Veterinary Animal and Fishery Sciences University issued notification for direct recruitment for various teaching posts, pursuant to which, the petitioners were recruited as assistant professors in various veterinary colleges affiliated to Karnataka Veterinary and Animal and Fishery Sciences University. The petitioners were relieved as veterinary doctors immediately on securing the relieving letter reported their duty to assistant professors in their college. Had introduced new contributory pension scheme, inverted comma, replacing the existing system of defined benefit pension scheme (OPS) with effect from 1/1/2004. It was iterated in the said notification that NPS is applicable only to the employees appointed on or after 1/1/2004 and the employees 1/1/2006 ಅಲ್ಲ 6. It is 1/4/2006. 1/4/2006. But several other petitioners, it was 1/1/4/2004. It was 1/4/2000.
State government.
Yes.
Request has been turned off and we have been elected. The feature is
Yes. Or 2006, apply for the post in the same or other departments under the state government service through proper channel, and on selection they are relieved by the competent authority or tendered with technical resignation under Rule 252B of the KCCR and subsequently joined the new post on or after 1/6/2006 will not be treated as new recruits and therefore will not be governed by the NPS and shall be governed under the KCCR, KCSR. And next para. While the things stood thus, in the pursuance of the notification dated 19/4/2011 issued by the Karnataka Veterinary Animal and Fisheries Services University, the petitioners were relieved from their duty as a veterinary doctors upon their technical resignation and were appointed as assistant professors in the veterinary colleges, respective colleges since 2012, because there are different petitions. Ministry of Personal Public Grievances and Pension, Department of Pension and Pensionary Welfare, by the Office Memorandum dated 26/7/2005, clarified that the modalities with respect to implementation of new scheme with respect to the employees who were availing the benefit of OPS now obtained change in the modality from department to other department are entitled to be continued under the OPS, full stop. The relevant portion part is reproduced as under. Further, the Ministry of Personal Public Grievances and the Pension Department of Pension and Pensionary Welfare clarified by order dated 28/10/2009 with respect to the modalities of implementation of the new scheme with the employees, who are availing the benefit of OPS now obtain change in the position or modality to department to other department. So, experience of the petitioner that despite the representation and request to the Secretary Department of Animal Husbandry and Fisheries for consider them Under the OPS, the respondent are not computing the past services rendered by the petitioner in the Department of Animal Husbandry and Veterinary Services, Government of Karnataka for pensionary and other monetary benefits, and also to continue the petitioner under the OPS. Whereas, on the contrary, the respondents are deducting the same from the salary of the petitioner. The Senior counsel of the senior counsel for the petitioner based reliance on the decision of the division head of the court in execution 10019 of 2021 dated 26/5/2022 in the case of Raghu versus State of Karnataka to contend that the absorption of services of an employee ensures continuity of service without interruption. The thread which connects the old employment with the new employment is legality of the employment. Normally, the absorption is resorted to after transfer or deputation, and an employee's services has been observed should be treated as transfer or deputed from one post to another so that there is no break in this service. The Learned Council Government Order Office Memorandum dated 11 June 2020 by the Government of India, Ministry of Personal Public Grievances and Pension Department of Pension, as held that the an option can be exercised by the petitioner within 3 months from of the issue of this office memorandum, and such employees who are appointed under NPS during 1/2/2004 to 28/10/2009 and are eligible to exercise the option uh, on option, and the cutoff date was 28/10/2009. However, in light of the official memorandum, there was an extension of time by another 3 months from the date of the issuance of memorandum dated 11 June 2020. And this option is always available to the petitioner hearing. The said submission is taken note of. In light of the office memorandum giving an extension of time for a period of 3 months, this court is of the considered view that the petitioner can exercise this option by giving a necessary representation to respondent number 3, which respondent number 3, and on such representation, the respondent to consider the same in light of the judgment decision of this court in the case of Raghu stated supra in accordance with law within a period of within a period of 3 months from the date of receipt of this order. Till the consideration of the representation of the petitioner, the respondents are directed not to deduct from the salary of the petitioner. Contributed towards pension. Correct. Not to deduct the contribution towards pension from the salary of the petitioner under the new pension scheme. Right? not to deduct the contributory pension under the new pension scheme. Till till consideration of the representation of the petitioners. Accordingly, the petitions. Yeah, that cannot be recovered also, no? That would be, you have to return it. If any amount so recovered under the new pension scheme, the same to be returned on in the event the no, that would be again in the event the petitioners fail to exercise the option. Yes.
Not coming the way. The government of India, it had started earlier and they gave this. Our case, it is extended, also becomes new issues.
But you were recruited in the year 112. Yes. It's an extension according to you. Page number 284. Two 84. Where does it refer to?
Page 283, victim number 2. All the central government employees who entered central government are set up a report 31 who are wrong by old pension scheme and who submit technical resignation on or after 1/1/2000. Take up new appointments under the state law. If they have more than a pension, the period of central government or central government only guys provided. Difference is where 284 or 1120 similar listing is extended. It's state board extended.
So this memorandum is in continuation of annexure M and N, we can say. The office memorandum issued on June 2020. But in this, there was no mention of those as the second paragraph of dates. But then that has to be read along with this office memorandum. Yes. Having given this option, you are ready to always. Could you understand what senior counsel is?
Employees who entered into service all of the actually 2023 and were governed by family here. Or what kind of efficiency does appointment or more not allowed to join the whole pension scheme under central because entry to the head scheme fees with effect from 1912 and no new entry can be allowed in the pension scheme under the law. However, such employee can seek pensionary or valuable from the previous organization or department. It's eligible under the rules of that organization or department for the period of
Extremely important.
all the central government employees who enter central government service or the government by own application on or after 1 month before take a new appointment and the state government will be eligible for grant of pro rata pensionary for the period of central government for central administration and the line has provided.
How to date it? What is the date? First, sir. After circular. Yes.
As for the Ministry of Finance going business. Required to resign from the previous board of administrative resignation will be treated as critical. These conditions even if the government servant has not mentioned the word technical, it's a process. If otherwise admissible under rule, it is given in such cases. Resignation in other cases, including where competence is not allowed the government servant to proper it not be treated as a technical resignation. Benefit of the resignation is treated as so, this is how technical resignation is. Is that it? Proper data, we have been selected to care of something. Normally, there is not even a acceptance of we are I did not say because these are all those.
When he says it is applicable to the petitioner herein,
entire scheme was not applicable. In government of Karnataka, on 31/3/2006, adopted the same scheme and issued a government order. Pursuant to that, now various except that the amendment is now over.
then how do you justify this? Yes, Mr. Consul. Yes. So without saying anything on the office memorandum, your representation, this petition to be treated as a representation and pass appropriate. Or the present representation which is already pending to be considered, or give a fresh representation.
It's a really hard one of this. Speakers are really people. What is this? So, I will be the 1 month. In 1 week, we'll be there. And in the interim, let them stop recovery.
That has to be done. No recovery. Then office memorandum and all will not take into consideration. Yes.
Except the offer.
Yes. You should have mentioned it. Anyway, take it out. No office memorandum, nor he has placed it on record. The
Yes, that's rule 32. Yes, 32.
Yes.
36(4).
Go back to the first the last part one paragraph. Like this will be office memorandum cancel. Then
I give the instances where similar treatment has been made to other employees, including the similar.
is this for dictation tomorrow for reconsideration? So let me look into the. Yes, I will look into the synopsis. Yes, we'll look into tomorrow for dictation. Purpose to what? So at least that he wants to say that central government, when he has issued a notification or office memorandum, that correct. So this has to be you give a fresh representation. You give a fresh representation. That has to be considered in light of judgment of this and in accordance with law within a period of 1 month from the date of receipt of this audit. And till then, no recovery or coercive actions against the petitioners. Yes, tomorrow for dictation. Yes, what is this matter? This is how is it listed for further hearing? When the counsel for the petitioner seeks time on the ground that he is unable to reach his client in spite of the best efforts made by the petitioner. Yes, Mr. Counsel, could you contact his workman or the permanent counsel appearing for the respondent corporation is able to contact the workman? Stop. In light of the said submissions are noted, released from partnered. Yes. Some settlement. So report settlement. This matter. This matter. Not like that other matter. No, central government to state government. Not, no, you won't do. Wednesday, if time permits, no? Synopsis. Yes. Yes. Where is she, Manjula D? Yes, madam. Now, no delay.
Answer melod is para 13.
Para
13, page 22. The present is the explanation of the first part is that agreed with the policy order was to find an applicable regulator. The appellate authority is not considered in spite of interpretation. Thereafter, the work the immediate basis is the heading field. His present reference is referred for adjudication. Second party has only stated that as per the DSO circular, the record pertaining to the minor punishment is to be only for the except no evidence is adduced